Welcome to Roman Manor. This lesson will explore the basics of subject matter jurisdiction. Specifically, its purpose is to serve as a primer regarding subject matter jurisdiction. You can also check out the law cited by the links in the description below. And with that, let's get to it. A quick preface. If you haven't watched the lesson on personal jurisdiction, I suggest you do so before proceeding. It will help you put this lesson into perspective as they build upon one another. That said, let's discuss subject matter jurisdiction. This lesson will proceed as follows. We will start by defining subject matter jurisdiction and then discuss why it is necessary. After that, we will examine the distinctions between general and limited jurisdiction before comparing and contrasting subject matter jurisdiction against personal jurisdiction and venue. Lastly, we will briefly mention the four subject matter jurisdiction bases. Subject matter jurisdiction, like personal jurisdiction and venue, is a crucial prerequisite that must be fulfilled before a court can adjudicate litigation brought before it. The concept is relatively straightforward. A court can only adjudicate a matter if it has been empowered to do so. Once the student understands how subject matter jurisdiction is defined, why it exists, and how it is distinguished from personal jurisdiction and venue, understanding the bases supporting it becomes that much easier. While we will briefly discuss federal question jurisdiction, diversity jurisdiction, and the other bases supporting subject matter jurisdiction, each basis will be explored in depth in separate videos. So how is subject matter jurisdiction defined? Stated broadly, subject matter jurisdiction refers to the court's power over a particular type of case or controversy. Black's Law defines it as, quote, jurisdiction over the nature of the case and the type of relief sought, and the extent to which a court can rule on the conduct of persons or the status of things, unquote. Subject matter jurisdiction ensures that courts only hear the matters they are actually empowered to adjudicate. It exists in large part because the founders wished to limit government power, and government power obviously included the judiciary. The U.S. is a federal republic, with government divided between the three branches and shared between the federal and state governments. Before the Constitution was drafted, the states had functioning court systems well suited to their citizens' particular needs. There was little reason to change this system, which, while in some ways imperfect, worked quite well. These differences between the federal and state governments created jurisdictional distinctions. For example, the various state judiciaries would continue to hear matters involving probate, family law, and divorce, the majority of all contract disputes, and most criminal cases. This makes sense. After all, most legal matters tend to be local, and the federal nature of U.S. government tends towards local resolution of local disputes. In contrast, the United States Constitution enumerated the powers granted to the federal government, while preserving all unenumerated powers to the states via the 10th Amendment. Article 3, Section 2 of the Constitution enumerated the subject matter jurisdiction granted to the federal judiciary. These state and federal jurisdictional distinctions are expressed in the doctrines of general and limited jurisdiction. Most state courts are courts of general jurisdiction. They can adjudicate virtually any matter brought before them by a plaintiff. Black's Law defines general jurisdiction as, quote, 1. A court's authority to hear a wide variety of cases, civil or criminal, that arise within its geographic area, and 2. A court's authority to hear all claims against a defendant at the place of the defendant's domicile or the place of service, without any showing that a connection exists between the claims and the forum state, unquote. State court jurisdictions are largely shaped by the legislatures of the individual states, but is limited in certain key instances. Importantly, these limitations include matters reserved to the federal courts via federal question jurisdiction. In contrast, federal courts are courts of limited jurisdiction. Black's Law defines limited jurisdiction as, quote, jurisdiction that is confined to a particular type of case or that may be exercised only under statutory limits and prescriptions, unquote. Article 3, Section 2 of the U.S. Constitution states the jurisdiction conferred to the federal courts. The provision cited is lengthy but necessary. It provides in part that, quote, the judicial power shall extend to all cases in law and equity arising under the U.S. Constitution, the laws of the United States, the treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, the controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects." Unquote. In short, the founders designed a judiciary wherein most legal matters would be adjudicated in state court. The federal judiciary would only hear the matters described in Article 3, Section 2. Taking a matter into federal court would require justification, a basis upon which subject matter jurisdiction could rest. Now, let's look at how subject matter jurisdiction compares and contrasts to personal jurisdiction and venue. Subject matter jurisdiction has several important procedural characteristics and distinctions between both PJ and venue. Let's take a look at each of these in turn. There are several important differences between subject matter jurisdiction and personal jurisdiction. In contrast to personal jurisdiction, subject matter jurisdiction cannot be waived. As we saw in the PJ lesson, a defendant may waive any challenge he may possess to personal jurisdiction and consent to the court's exercise of PJ over him. But waiver is impossible with regard to subject matter jurisdiction. However, unlike a court's exercise of PJ, subject matter jurisdiction can be challenged at any time during the litigation's life cycle. Federal Rule of Civil Procedure, Rule 12H3, provides that, quote, "If the court determines at any time that it lacks subject matter jurisdiction, the court will dismiss the action." Unquote. Again, as we saw in the PJ lesson, if the defendant intends to challenge the court's exercise of personal jurisdiction over him, he must do so in his answer or first motion. A failure to do so constitutes a waiver and consent to the court's PJ. But per Rule 12H3, a defendant may challenge a court's exercise of subject matter jurisdiction over the litigation at any time in its life cycle. And this means any time. Subject matter jurisdiction can be challenged in the answer, by motion, or even on appeal. Venue is distinguished from subject matter jurisdiction in that venue solely refers to the proper geographic space in which to bring an action, while subject matter jurisdiction refers to the court's ability to adjudicate a particular type of case. A court can have subject matter jurisdiction over a case, but nonetheless be an improper venue. For more information on this important procedural aspect, see our video on venue basics. So we've seen what subject matter jurisdiction is and why it exists. We've also looked at how it's distinguished from personal jurisdiction and venue. Let's briefly discuss the four bases upon which a court's subject matter jurisdiction can be based. Keep in mind, this is only an introduction. Each of these bases is discussed in depth in separate lessons. Federal question jurisdiction. A plaintiff invokes federal question jurisdiction when his claim arises under the Constitution, federal law, or U.S. treaty. Diversity jurisdiction. Generally, a plaintiff invokes diversity jurisdiction when his litigation crosses state lines. It requires that each claim exceed the amount in controversy minimum and that the parties on each side of the litigation be completely diverse from one another. Supplemental jurisdiction. A plaintiff invokes supplemental jurisdiction when his claim does not meet the requirements necessary for federal question or diversity jurisdiction. Usually, such claims tend to be state law claims related to a separate claim that does meet the criteria for either FQ or diversity jurisdiction. Removal jurisdiction. In contrast to the plaintiff's election to use supplemental jurisdiction, it is the defendant who can invoke removal jurisdiction. This basis permits a defendant to remove a case from state court into federal court. Okay, so we've defined subject matter jurisdiction, examined the reason it exists, seen how it compares to personal jurisdiction and venue, and briefly looked at the four bases that can support it in court. As we already mentioned, there are separate lessons that cover each of these bases in depth, and it is highly recommended that you watch each of those. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.